welcome to the Five Play YouTube channel. Open mic number 255. Hope everyone's doing pretty well. It's my evening, early morning for the Australians, late night for Jay and the Europeans. Thank you so much for joining us, Jay.
Hi.
It's late. So, yeah, we got a couple of new documents from in Kratz lawsuit. This is from the defendants. It appears that they've hired one lawyer to represent them. So I haven't read. There's two documents. One's about 30 pages. It's not that much text because there's an index, or not an index, but the front part you'll see it. So there's probably, I'm guessing, 20 pages of actual text, something like that. In the second document, there's 8 pages. Now, I've read some of each one. I have not read all of it. I will tell you it's going to get into, like we got into before with his documentation. It gets into some lawyer speak as it is. We'll get to it as best we can, understand it as best we can. Anyway, before we get started with that, I want to let everyone say hello. Sunshine Christina. Hello, Sunshine. You're muted.
Greetings, everyone. How's everybody doing on this Sunday or Saturday or Monday, depending on where you're at? I've had a rainy day, but my garden's happy about it. And I'm excited to see what the liars versus the liars. Like, that's like how I look at this thing here, this civil suit.
Well,
keep me relevant. Yeah. Give me money. Feed my narcissistic personality attention.
Yeah, it's going to get interesting if this moves forward. We'll see.
I always think about what Zellner said: "A moth to the flame."
There you go. Thank you, Sunshine. I'm glad you're doing well and happy for your garden with the rain. Susan, how are you?
I'm good, Jack. Thank you. Just have a beautiful Sunday here. Sunny, 82 degrees. Just very pretty Mother's Day.
And just briefly, we'll talk about it a little bit here in a second, but I know you've been keeping pace with the Karen Reed trial.
Yes, I have.
Holy smoke. Holy smoke.
Yeah.
Yeah.
It's pretty wild. It's amazing.
It is. And I'm gonna ask you about something here in a minute. Let's say hi to Jay. How are you doing tonight, Jay?
Yeah, I'm all right, thanks. Just want to say hi to everybody and everybody that's viewing at the moment.
Excellent. Thank you for joining us, Jay. I know it's already probably midnight or later for you. So
early Monday.
There you go. So anyway, and I would be, for me, because I'm trying to catch up and stay kind of pace with what's going on now with the Karen Reed stuff. And I know a lot of people out there are, and that's not what tonight's about, but I have to mention it. I have to talk about it a little bit because there's been so much crazy testimony this past week for those that are keeping up. But I did want to ask you something, Susan, how much maybe you heard about this. And I just heard about it. It was either yesterday or Friday night. I read, now this is on X, so don't kill me. I mean, you cut through the butter and all the crap on X, you can still get nuggets of truth. But
I'm not an Xer.
I understand. I'm not on there nearly as much as I was.
Yeah.
But I read that on Chris Albert's phone, there was some very bad stuff found.
Chris Albert's phone?
Mm-hmm.
Oh, no. That's a rumor. It's the wrong Chris Albert. I heard Turtle Boy talk about this on his show last night. It is not the child porn and stuff like that. No, that's false. It's wrong, Chris Albert. The guy's name is Chris Albert, but the ages are different. It's not the same person.
Okay. I figured if anyone knew, you would. I was actually gonna DM you tonight and ask you, and I thought, well, if
That's according to Turtle Boy, which Aiden Carney, he knows what's going on. So yeah, I'm happy to put that to rest, because that's a bad rumor to go around about somebody if it's not true.
It's terrible. It's absolutely terrible. Okay, well, I'll just kick that one out of my brain and move on.
No matter what an asshole the guy is,
True enough.
How big of an asshole, yeah.
Well, I mean, there was a lot of interesting things that, kind of reared its head this past week. One of them was the shoe, right?
Yeah. That's interesting. Well, especially, not the fact that the one sole is black and the ones in evidence are white, or it looks black at the scene. But the fact that they had, I don't know how the hell they had the right shoe in the bag from the scene at 34 Fairview. It was the left shoe they found at Fairview, which had already been entered into evidence by, I think, Guarino or somebody else.
Gallagher, maybe.
Gallagher, sorry. Yeah, thank you. Days earlier. And then how that bag got marked with the right shoe to be from Fairview and not from the hospital is where they collected it. I'll never know. I don't know.
Well,
but,
I mean,
I'm sure the defense is going to bring that up. Just their whole lack of
chain of custody.
The care of evidence, everything. It's so laughable. It's just unreal, and it's not incompetence, Jack. It's all on purpose.
Oh, there's no doubt in my mind. But
yeah,
and I think, Christina, you'll love this too, and Susan can probably back me up. And I can give you some links if you're interested, and I don't know how much you watched of it, Sunshine. But this Gallagher, he was I think he's retired now, isn't he, Susan?
Yes. Yeah, I believe so.
He was an investigator, detective, whatever, on the local police department. And he's under cross-examination. And I've been watching this on the DUI guy, Larry. I think his last name's Foreman. Anyway.
He's the snowblower.
Yeah, but, and not only that, but this guy acts like he never heard of an evidence log.
I know. They all act like that. Like a log?
Right.
Like Buchanan said, well, I've never seen anything like that.
Right. And I was like, wait, what? How can you not know about the evidence log and chain of custody?
He knows about it. He knows about it. They're playing dumb because they're trying to make it incompetence instead of intentional, right? It's the playbook all wrongful convictions have. Because even if he didn't know about a log in his real life, he knows about a log from a movie, from a TV show. You know what I mean? Because even cops on TV have a log.
He'd been a cop for 20, 30 years, whatever. How could you not?
A detective, for God's sake.
And I'll give you one more before I stop bitching about this. When they were at the scene, apparently they didn't bring any evidence bags or anything to collect evidence. So they found these blood spots, this areas of blood, whatever, in the snow. So they got several red Solo cups, put the snow with the blood in these red Solo cups. They were unsealed. They didn't have any bags to put it in, so they ran down to the Stop and Shop and got some brown paper bags.
Or somebody had that bag in their car, Jack.
or
I
right,
think
one of the
that's where
two.
it came from. Yeah.
Well, that's
Somebody's
actually
lunch.
that's actually worse.
Yeah. It is.
So
So
you have unsealed DNA evidence in a bag that came from God knows where. So and this guy acts like it's
with
no big deal.
leftover beer pong cups holding it.
Right. Right.
Yeah.
You know but I'll tell you what's even worse, Jack, is when Buchanan was at the scene on, I think it was the 4th of February and the 11th of February, picking up more taillight pieces. There's no photographs. There's no description of where they got it. Nothing. He just put in his report that they found them all in the same general area. That's how they, and the same goes for I think it was the 18th, the 14th, the 18th. I don't know. They kept finding taillight until, like 3 weeks later.
I think so. That went on for 3 weeks, didn't it?
Yeah. And
That's
the last pieces were huge. They were like 8 inches long and 5 inches tall. Like, and all the snow had been gone. I guess it was pretty unseasonably warm after the blizzard.
Right.
And it's such a joke. It is such a joke. And he, with a straight face, sat on that stand and said, well, it was all in the same general area is where they were found.
Why didn't they photograph any of it?
Well, the photographs they do have some taillight piece photographs, but there is no context to them. They could be on anybody's yard anywhere. You don't see the house, you don't see the flagpole, you don't see the fire height. They're not measured. They're just little close-up photos of little pieces of taillight.
So they just did the close-up and they didn't do the stand back.
Yeah.
Oh my God.
And they didn't, coordinate them and say where exactly they were laying. And there's 47 pieces.
Oh my God.
All together. It's insane.
After Proctor got done, I'm sure there was.
So
It's insane.
So it's interesting to me that is there a 911 call to the address?
Yeah.
To the address?
There's actually 2.
Okay. So upon finding the body, they called 911, correct?
Yep.
Yes.
Jennifer McCabe did. Sorry.
Okay. That's okay. So,
And passed out in the snow.
They responded to a potential crime scene. They sent a seasoned detective, right? And they're choosing to go with I didn't know what a crime scene log was. I didn't have proper items to collect evidence. Now, when did Karen Reed, because, I followed some of this case, but I am definitely not clear on the first 3 or 4 days. Was Karen Reed a suspect from the beginning?
Yes.
Okay.
Within hours. Yeah.
So were they treating it as a crime from the beginning?
Yes. They deduced in their investigative, amazing abilities that she hit him with her car. They'd never seen the car. Haven't seen the car yet. Jen McCabe told him she had a cracked taillight. They didn't have any taillight pieces. They didn't find that until they didn't find the first piece until I think it was 5:45 p.m. They took John to the hospital at 6:20 a.m. or something like that.
So
they left the scene unsecured for hours, all day long. They didn't leave a cop sitting there in a car. They didn't have tape up, nothing. They just left.
And the narrative they're going with, it was a crime scene from the beginning.
Yeah,
and
they didn't tape it off. They didn't tape it off. They didn't step foot inside that house. The lead investigator, which was State Trooper Michael Proctor, he didn't go inside that house. Brian Albert, which owns the house, Brian and his wife, they lived there for that house had been. Yeah, they had been in that family for decades. He's also another cop that is a first responder. Once he finds, let's say he's not awake, he gets awake. He doesn't step foot outside to find out what the hell's going on in my front yard. And you got John O'Keefe laying dead, dying at his front, basically feet from his front door.
And you got Karen screaming at the top of her lungs.
Yeah.
You got, 10 police cars? You got ambulance? You got the fire truck? I mean.
Yeah. And you don't go outside? What?
He says he slept through it, him and his wife both.
And no one comes inside and says, hey, you got a guy laying out here in your yard.
Well, his sister-in-law did. After John was taken away, she went in and supposedly woke him up. The German Shepherd didn't make a peep that slept in their bedroom. I believe he was gone. He was taken out of the house the night prior. Had to be.
I think Chloe didn't make it the rest of the night.
Yeah, I think their daughter took Chloe with her when she left.
Well, I think Chloe moved on. I hate to say that, I do. But, to say later that we had to rehomed the dog, family pet, for 7 years. Well, if the dog didn't do anything, why would there be a need to do that?
No, when they rehomed it, the dog had a history of biting people.
I understand.
He didn't go on with other dogs.
I understand.
And like in May, I think it was after John died, in the end of January. I think in May she bit a woman again that had a little dog and got into it. It got out, and so she had bit another person. Sent 2 women to the hospital, I think. So they did have an incident. I
get it. I do. I get it. Still, they knew this dog had the history, but then suddenly chose after this incident to get rid of the dog. I'm sorry for me. I have an issue there.
With what John's right arm looks like. That's the whole issue with the dog, because obviously the dog bites and scratches.
There's no doubt in my mind it's dog bite and scratches. There's no doubt.
Right.
Well, and on top of this, Sunshine, Christina, and it's not really talked about a lot, but they knew from the beginning that John had severe assault on his head, back of his head, side of his head, severe assault. Yeah. I'll tell you one more thing, and we're going to move on. I promise. This video that link you sent, Susan, from Michael.
Oh yeah, the microdots.
The interaction at the bar, at the waterfall bar.
Oh. And I don't think for a second that they were out to kill John. I think they wanted to fight. I think Buchanan wanted to fight and kick his ass because he wanted his girlfriend. And What's
What's the other guy's name?
Buchanan.
There's Buchanan and there's Brian Higgins.
Massachusetts State Police, MSP.
Okay.
Yeah.
And John was a Boston cop. And they were all out drinking. And Buchanan had been flirting with, and she mutually was flirting back and forth with his girlfriend on the sly, right?
I thought that was Higgins.
Oh, Higgins, yeah. I'm sorry. Yeah. It's Higgins that had an eye for Karen. And she had ended up kind of ghosting him. They had some text interactions. Maybe they met a couple of times, but
Little flirty stuff. Nothing over the top, but still flirty. So he's wanting to hook up with her.
yeah. And I think she decided, he's not for me. But he was all about it, and he wanted to fight John that night. They'd been drinking all day.
Higgins and who was it that had been drinking basically all day that day? It was
Brian Albert.
Brian Albert.
They'd gone to New York for a cop's funeral and drove back from New York to Massachusetts to Boston. And I'm sure they were drinking all day. I'm sure they went to a cop's wake as well.
Yeah.
They're just drinkers. That's what they do. I mean, they're serious about it.
My middle two kids' dad said that when you drink all day long, at the end of the night, there's two things you want to do, and they both start with an F. And when he said that, it really made sense because it's the truth, right?
Yeah.
It is. And he was the epitome of that during our relationship. He's matured, thankfully. So I have experience with people like that, and their favorite excuse, if they don't get the one they want out of the two F's and end up doing the other, is, I don't know what you're talking about. I don't remember anything.
Right.
Yeah.
I got to correct myself. Thanks, Nan. Higgins was a Fed, actually. He was ATF, was it?
Yes.
Yeah.
Higgins is a Fed? Okay.
Yeah.
Yes.
And he had an office. He had an office at the Canton local police department.
Of course he did.
Yeah.
So
anyway, it's all on video at this bar that he kind of calls them out just before they're leaving. They invited him over to this house. And I really think that, that a fight went down. I think somebody knocked him over. I suspect it was Colin, but, we'll never know. Somebody knocked him over, and he hit his head on something, the back of his head. And it basically immediately incapacitated the guy. I mean, he was as good as gone.
And the dog somewhere in there attacked him. Chloe did.
Dog got in on the fight. Yeah.
Yeah. It's I mean, this waterfall video that Microdust did, you got to watch it because you can see this interaction. And I never really I've seen this video before, but I never really paid too much attention to it other than seeing John and Karen.
They showed
I never
it
really
in the first trial, and nobody caught all that, Jack.
No, I know.
Until Microdots. There was another guy, I think, that I first saw that pointed out that little alley shuffle that John did at the bar. Like, okay, you want to fight? He kind of shuffled his feet. But anyway, Microdots did just an amazing job of really focusing in on that horrible video and making it where you can actually see what's going on.
Yeah. Andy, that's close to what it means, but not quite.
Flower arranging and fishing. Two F's.
No. Yeah. No. Oh, sorry.
And then, Higgins texted John when John was on the way to the house. You coming here with 3 question marks? It's all just so obvious. And, Buchanan, who's the lead investigator's boss, didn't see that, he should be a suspect in any way. None of that meant anything.
So just to kind of provide some context for Mr. What's a Log, I Oh, that's interesting too. Okay, so I've been kind of just playing around looking, and the first guy, Gallagher. Gallagher worked a violent home invasion in 2017 of an elderly couple. He was part of the DEA task force from 2005 to 2018. He's working a cold case investigation that's still open. And then this guy that you were just talking about, Higgins.
Oh, Higgins, yeah.
Okay.
Brian.
He's closely associated with an ATF special agent, Matthew Kelsch. Okay. Matthew Kelsch.
I've heard that name.
Yep. Matthew Kelsch is also ATF. And he was involved in the Aaron Hernandez case.
He's the one that helped Higgins, I believe, download the text messages off his phone at the FBI kiosk. He cherry-picked messages off his phone to hand over.
Yep.
And then destroyed it. Yeah.
Mm-hmm.
Yeah. That was Welsh, I think. Welch, or is that what you just said?
Kelsch with a K.
Oh, Kelsch. Yeah. Thank you.
Yep. And so he is very capable of digital forensic maneuvering. And even if they destroyed his phone and his SIM, if someone can get his number and has access to the right tech, they can get his stuff. Because nothing.
I'm sure the feds probably have it. The feds did an investigation into the investigation.
Yeah, but they're not going to do anything until they're made to. I mean, I want to have hope that what's his name? Kash Patel.
Yeah.
I want to have hope that he's trying to do the right thing. I want to believe that, because I think if that's the case, if he was to ever hear of the Stephen Avery, Brendan Dassey case, I think that he may be able to do something. I believe that, if he is as honorable as he portrays himself to be. But I don't know. It's interesting. We mentioned that the ATF guy had an office at the police department.
Local police department.
Yeah, because Wisconsin doesn't advertise that, but they've done that they've had DOJ or DCI officers assigned to each police department for, I don't know, since the 90s. So they act like they had to call them in, like it was a process. But that's one of the things that really, once I realized that it's not near as a big deal as they make it out to seem, they really made it seem a lot. They use that excuse to make it seem like it's time consuming, and it takes paperwork and phone calls, and it allows them to account for these missing blocks of time in an investigation that aren't really missing, because they're literally in the building with them and probably already on the scene. If it's something, I don't want to use the word exciting, but you know what I mean? Like if it's not the normal thing and they're on duty, they're going to be out there anyway, because that's their gig.
Well, this whole MSP division, the Massachusetts State Police, is assigned to the prosecutor's office.
Mm-hmm.
There's like, I think Buchanan said there's 5 of them, or there were at that time. So yeah, and they donate to his campaign every time he runs, and this guy has been the what is it, Jack? Same as what Kratz was.
Oh, prosecutor.
Not prosecutor, the district attorney. This guy's
Okay,
been
well, yeah,
district
district.
attorney for over 30 years, and I think only one time, maybe 20 years ago, somebody ran against him, but basically,
Ran unopposed.
yeah, ran unopposed.
Wow.
Wow.
I did want to bring up one more thing, and Nansloff stated it. Don't think the prosecutor will call Proctor or Higgins. If he doesn't, that's going to look really, really bad for them.
Brennan
Really.
is, Brennan is the prosecutor.
Yeah, Brendan.
is
Yeah, he's a
special.
hired gun. That's another thing.
Hired
We
gun.
mentioned the last time. Yeah, he's not part of the local prosecutor's office. They went outside that group and hired someone, and they got 50. They got 50 prosecutors in that office.
Yep. I don't think.
And they went.
I think maybe nobody would take the case. It was. So
Well, I
bad.
think so too. I think they said,
Or
"No,
he just
no, thank you."
didn't feel like anybody was dirty enough to prosecute the case. Like Brennan,
Has
oh my God, he's such a liar. He's
Has
just
anybody looked into the DA they selected to prosecute it?
he's actually not. No, you mean the prosecutor? He's actually a defense attorney. He defended Whitey Bulger.
Yeah.
And he's
they-
just a fucking snake, a liar. I mean, he's accused the defense attorneys of, doing all this dirty stuff, which is exactly what he's doing.
Oh yeah. I mean, well, that seems to be a theme these days.
Yeah, I'll do this, but I'll keep.
Projection, right?
Yep. Yeah, that's been. Going
Yeah,
on
I
for
don't
time.
think they'll put Proctor or the Alberts on the stand either, Nan. But I don't think it's going to matter. I really don't. I don't see
I think
any way.
if he doesn't, I think. I mean, I could be wrong, but I think Jackson will call him as.
He'll for sure call Proctor.
Oh, no doubt.
For sure. And I'm sure probably Higgins as well.
Yep.
But yeah, I mean,
I agree. Well,
to me, it's already so much evidence against the investigators and the whole team.
awful.
And there's so much more to come. But
Yes.
it's so bad. There's so much more juicy stuff to come that's already come out. There's just no way they're gonna convict her.
I don't see how they can. I mean, to me, it's got. There's so much reasonable doubt. That's really the real term for the jury. Reasonable doubt. What did these guys do? When did it start? It's like that phone call. I swear I'm going to shut up. I'm going to get these documents up and we'll start talking about it. From almost the beginning, this phone call between Proctor and I don't remember who it was. And whoever this other person was said, "Oh, well, I guess the homeowner's going to get a lot of shit for this." And Proctor said, "No, they're not."
He's a Boston cop too, is what he said.
Yeah. Who was Proctor talking to? Do you remember?
I think that was his high school buddies, that conversation.
Yeah, that's right. Yeah, okay. Anyway. All right. Got a lot of familiar faces in the live chat tonight, and I want to thank you guys for going through this a little bit and talking about it, because it is a hot case. There's several ones that go in the Delphi case, so there's other ones too. But we've got I saw Moses in the chat, Nansloff, of course, ACV, Under Your Scars, Gloria, Three Ravs, Dr. Suckman's in the, hey, Doc, you can join us here in the live if you want. I promise Susan won't bite more than once. Maybe twice. I'm kidding. Glad to see you, Doc. There's Sheila Hawkins. We just got a bunch. Candy, I don't think I know Candy.
We got Kay with us too. Hey, Kay.
I saw Kay. Yep.
Yeah.
Sila, Pete Moss. Anyway, let's get these. Let me scroll this down here. I'm going to pop these documents on here, and I'll show you. And I will make these available. If you look up here at the very top, you'll see that this is what the hell is that? Doc 15, right there at the very top. And then the second one. Yeah, and then this other one is Doc 16. So the shorter one is the second document, the new one. So anyway, I hope you guys feel like reading tonight. We can all split it up and share. But I would certainly appreciate the help. I got it blowed up there, so everybody can see. Okay, well, I'm going to start us off, and then I'll pass the hat. Is that okay, everybody?
Fine with me.
Not gonna. I'm not. You guys can do what you want, but I'm not reading the citations. We will read the footnotes if they, if we have any. I don't even remember if we do or not. Probably, but anyway, like I said, this is. I don't remember this lawyer's name, but we'll get to it. Anyway, this is to Judge J. Philip Calabrese. That's how I pronounce it. Motion defendants to dismiss complaint, or in the alternative, motion to compel arbitration. Which in a lot of civil suits, we found this out. We know that in most civil suits, a judge will really heavily encourage the parties to settle. Get it out of the court, go settle it before more bad shit comes out. Right? All right, yep. Let's start off here. Pursuant to Fed R Civ P, and it gives the whatever. Defendants Transition Studios LLC, Christopher Reck, Ralph McGreevy, John Fessick, and Andrew Hale, Convicting a Murderer, DocuSeries LLC, and the Daily Wire LLC, collectively defendants, move to dismiss plaintiff Kenneth R. Kratz's March 20, 2025 complaint with jury demand complaint for failure to state a claim upon which relief may be granted, lack of personal jurisdiction, and a lack of subject matter jurisdiction. In the alternative, this court should compel arbitration and stay this matter pending arbitration. For these reasons, and the reasons shown in the memorandum in support of this motion, which is incorporated by reference here, plaintiff's complaint should be dismissed. In the alternative, the court should compel arbitration and stay these proceedings. This is the lawyer here, Griffin R. Rails. How would you pronounce that, Susan? Rails, okay. And looks like there's another one, John Greiner, and they're out of Cincinnati. So, and it shows the counsel for defendants. So I think we got the table of contents, and I'm going to skip through this. I don't think there's really any reason to go through that. Let me scroll down here. Then we got the statutes listed. Of course, I'm not going to read those either. Sorry, I think I went too far here. I did. All right, I'll read the statement of issues, and I'm going to turn it over. Issue 1. Has plaintiff pled a breach of contract claim upon which relief may be granted? Issue 2. Has a plaintiff pled an unjust enrichment claim upon which relief may be granted? Issue 3. Has plaintiff pled a conversion claim upon which relief may be granted? Issue 4. Does Ohio recognize a standalone claim for accounting? Issue 5. Are plaintiff's conversion, fraud, and civil conspiracy claims barred by any applicable statutes of limitations? Issue 6. Can this court maintain personal jurisdiction over Andrew M. Hale and the Daily Wire, LLC? Issue 7. Can this court maintain subject matter jurisdiction over plaintiff's claims based on diversity? Issue 8. In the alternative, should this court compel arbitration and stay proceedings? Susan, you want to read for a while? Read as much as you want. Turn it over when you're ready.
Okay, Jeff. A summary of the arguments. Issue 1. Plaintiff's breach of claim should be dismissed against defendants Transition Studio, LLC, Christopher Reck, Ralph McGreevy, John Fisek, Andrew Hale, and the Daily Wire because he fails to state claim upon which relief may be granted. Issue 2. Plaintiff's unjust enrichment claim should be dismissed for failure to state a claim upon which relief may be granted. Issue 3. Plaintiff's conversion claim should be dismissed because plaintiff does not have ownership over the property, and plaintiff alleges only that Transition Studios, LLC's employee converted the property. Issue 4. Ohio does not recognize a standalone claim for accounting. Therefore, the court should dismiss plaintiff's claim for accounting for failure to state a claim upon which relief may be granted. In other words, none of this makes sense. Issue 5. Plaintiff's conversion, fraud, and civil conspiracy claims are barred by applicable statutes of limitations. Issue 6. This court cannot maintain personal jurisdiction over Andrew M. Hale and the Daily Wire, LLC. Issue 7. This court cannot maintain subject matter jurisdiction over plaintiff's claims as he has failed to establish diversity jurisdiction. Issue 8. In the alternative, this court should compel arbitration pursuant to the parties' agreement. Memorandum in support of motion of defendants to dismiss complaint, or, in the alternative, motion to compel arbitration. Pursuant to federal civil law, defendants, Transition Studio, and all of the defendants et al., convicting a murderer, docu-series, and the Daily Wire, moved to dismiss plaintiff Kenneth R. Kratz's March 20, 2025 complaint with jury demand for failure to state a claim upon which relief may be granted, lack of personal jurisdiction, and lack of subject matter jurisdiction. Seems like it's all repeated, all of that so far.
It did repeat it.
Plaintiff's complaint should be dismissed. A. Plaintiff fails to state a claim upon which relief may be granted. Under federal civil law, a plaintiff is required to give a short and plain statement of the claim showing that the pleader is entitled to relief. To meet this standard, a complaint must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. That's Ashcroft v. Iqbal. Facial plausibility requires a plaintiff to do more than simply state legal conclusions or recite the elements of a cause of action in boilerplate fashion. A complaint must set forth factual allegations that are enough to, quote, raise a right to relief above the speculative level, end quote. The court need not credit bare legal conclusions unsupported by factual underpinnings. Quote, while legal conclusions can provide the framework of a complaint, they must be supported by factual allegations. End quote. That's from Ashcroft.
Yep.
And then Emerald Forum Corp versus Chamberlain Group says this court will not, however, accept conclusions of law or unwarranted inferences cast in the form of factual allegations. 1. Plaintiff does not allege he has a contract with Transition Studios, Rec, McGreevy, FISEC, Hale, or the Daily Wire. To establish breach of contract, the plaintiff must allege the existence of a contract, performance by the plaintiff, breach by the defendant, and damages. To survive dismissal, the allegations must also include 1. The specific terms of the contract at issue, and 2. Sufficient factual allegations of the defendant's purported breach. Northampton Restaurant Group Inc. versus First Merit Bank. In that, it says applying Ohio law, affirming dismissal of contract claim where the plaintiff failed to attach any contract or include language of the specified contractual provisions allegedly breached. Under Ohio law, quote, a breach of contract occurs when a party to the contract fails to perform a contractual duty. One who is not a party to the contract cannot be in breach of the contract. Let's see.
Okay.
And then there's another law that has a quote. It is axiomatic that those not a party to a contract cannot be held liable for breach of contract. Here, plaintiff alleges only that there is an agreement between plaintiff and CAM. See complaint. Quote, the January 15, 2018 agreement was signed by REC on behalf of Transition Studios with a promise to plaintiff to present a long-form contract with the same terms on February 1, 2018. A long-form development and rights acquisition agreement was in fact executed by the parties on or about February 2nd of 2018. The development and rights acquisition agreement superseded the January 15, 2018 letter of understanding. Agreement attached to complaint as Exhibit 2. This agreement constitutes the entire agreement between the parties with respect to the subject matter within, and shall supersede all previous understandings and agreements. This letter of understanding precedes a long-form agreement to be signed February 1, 2018. The agreement was signed by plaintiff and CAM. No other defendants were parties to the agreement. Therefore, plaintiff has not and cannot allege a breach of contract claim against Transition Studios, REC, McGreevy, FISEC, Hale, and the Daily Wire. Therefore, the court should dismiss the claim for breach of contract against Transition Studios, REC, McGreevy, FISEC, Hale, and the Daily Wire for failure to state a claim upon which relief may be granted. Breach of what contract?
Right.
Andy
Plaintiff-
Hale.
Andy Hale, yep.
Yeah. Oh, yeah.
Plaintiff's unjust enrichment claim should be dismissed. Under Ohio law, to succeed on a claim of unjust enrichment, a plaintiff must allege, quote, 1, a benefit conferred by a plaintiff upon a defendant, and 2, knowledge by the defendant of the benefit, and 3, retention of the benefit by the defendant under circumstances where it would be unjust to do so without payment. And then there's some laws cited. A, plaintiff fails to allege unjust enrichment. Quote, the purpose of an unjust enrichment claim is not to compensate the plaintiff for loss or damage suffered by the plaintiff, but to compensate the plaintiff for the benefit he or she conferred on the defendant. Citing Johnson and the Microsoft, It is not sufficient for the plaintiff to show that they have conferred a benefit upon the defendants. Plaintiffs must go further and show that under the circumstances, they have a superior equity so that, as against them, it would be unconscionable for the defendants to retain the benefit. Liberty Insurance v. 3C Body Shop. Absent an indication in the pleading of a benefit conferred by plaintiff, the unjust enrichment must be dismissed. Here, plaintiff fails to allege any of the elements of unjust enrichment. God, and Kratz is a lawyer.
Yep.
Here, plaintiff fails to allege any of the elements of unjust enrichment. First, plaintiff fails to allege that he conferred a benefit onto defendants. Rather, his only allegation is that REC, acting as an executive officer for Transition Studios and CAM, used a substantial share of the monies raised for the Convicting a Murderer project to support his own lavish lifestyle and to satisfy personal and business debts which were unrelated to the project. Complaint, paragraph 47. However, plaintiff does not allege that the money allegedly used by REC was plaintiff's money, nor does plaintiff allege that he conferred any benefit to REC or any other defendant.
Now, hold on a second. Lavish lifestyle? What?
Yeah. Remember that in Kratz filing?
Yeah.
He accused
Interesting.
REC of, spending it all on himself.
Yeah.
Second, plaintiff fails to allege that defendants had knowledge of the benefit conferred by plaintiff. Instead, the only knowledge plaintiff alleges is defendant's knowledge of plaintiff's embezzlement concerns, in quotes. Complaint, paragraph 50. However, plaintiff's vague and unsupported allegations regarding embezzlement are irrelevant to adequately allege defendants had knowledge of any benefit conferred on them by plaintiff. Third, plaintiff fails to allege, because he fails to allege any benefit conferred by plaintiff, that defendant's retention of a benefit would be unjust without payment. Instead, plaintiff alleges that only that, quote, defendants have continually failed to provide project status or other relevant updates despite frequent and periodic demands from plaintiff, end quote. This allegation is disconnected from any benefit conferred by plaintiff. B. Plaintiff's unjust enrichment claim is barred by well-established Ohio law. A, quote, claim for unjust enrichment will not lie when the subject matter of the claim is covered by an express contract, end quote. Let's see. Ohio law prohibits seeking equitable relief for unjust enrichment where a contract exists between the parties. Gosh, there's a lot of case law in this thing.
Oh, yeah.
Another case law upholding dismissal of plaintiff's unjust enrichment claim because, quote, unjust enrichment cannot exist where there is a valid and enforceable written contract. And then another one states a party seeking a remedy under a contract cannot also seek equitable relief for unjust enrichment. Assuming arguendo that plaintiff adequately pled unjust enrichment, he has not. The complaint raises an unjust enrichment claim that is incompatible with well-established Ohio law.
You want to read this footnote? I'm not
Yeah,
sure.
I didn't. Oh, I see the. No,
Yeah,
I
it's
see
number.
the one.
Yeah, it's right there. Yeah.
Let's see. Applying Ohio law, the court dismissed, among other claims, plaintiff's claims for unjust enrichment and promissory estoppel because, quote, where an express contract covers the subject matter of an equitable claim, the equitable claim will fail as a matter of law, end quote. And then Ohio
No.
law does not allow parties to seek damages under quasi-contractual theories of recovery, such as a claim of unjust enrichment when a contract governs the relationship. End quote. Some more case law.
Yeah.
Plaintiff admits the agreement is a valid and enforceable agreement between plaintiff and CAM. Complaint, paragraph 24. Moreover, plaintiff raises claims for both breach of contract and unjust enrichment. Paragraphs 25 to 53. The unjust enrichment claim arises from rights plaintiff alleges he has under the agreement. And then at paragraph 46. Likewise, the breach of contract claim arises from an alleged breach of the agreement. Paragraphs 27 and 44. Both the breach of contract claim and the unjust enrichment claim relate to the agreement, and the unjust enrichment claim fails under Ohio law. Therefore, the court should dismiss plaintiff's claims of unjust enrichment for failure to state a claim upon which relief may be granted. Number 3, plaintiff fails to adequately allege defendants converted plaintiff's intellectual property. In Ohio, quote, the elements of conversion are 1, plaintiff's ownership or right to possession of the property at the time of conversion, and 2, defendant's conversion by a wrongful act or disposition of plaintiff's property rights, and 3, damages. Poston ex rel. Poston versus Shelby Love says conversion is based on affirmative acts. Mere negligence in the care of personal property is not a conversion, even though such conduct results in injury to or loss of the property. Another case law, an intentional and willful tort committed by an employee constitutes a departure from his employment so that the employer is not responsible.
More case law.
Yeah, more case law. I'm not going to read all those cases. I hope you don't care.
I don't. I really don't.
Yeah. Here, plaintiff does not allege conversion by defendants. Instead, he claims Transition Studios employee Brenda Schuler gave exclusive case materials and insights to attorney Michael Griesbach. Complaint, paragraph 56. However, plaintiff admits that this purported conversion by Transition Studios employee was done without its consent or prior knowledge. In paragraph 59, quoting an email in which it is clear the employees shared information with a third party without defendant's knowledge, this purported conversion constitutes a departure from Brenda Schuler's employment for which defendants are not responsible. Additionally, plaintiff fails to allege the elements of conversion against defendants because plaintiff granted CAM ownership of the work product and intellectual property connected to the Stephen Avery and Brendan Dassey cases. See agreement, subsection 9. Quote, the results and proceeds of any services rendered by plaintiff or materials created by plaintiff in connection with the Stephen Avery, Brendan Dassey cases shall be deemed a work made for hire specifically ordered by CAM, with CAM being deemed the sole author of such results, and proceeds and the owner of all rights of every kind or nature, whether now known or hereafter devised in, and to such results and proceeds, and in the event any such results and proceeds are not considered works made for hire, plaintiff hereby irrevocably assigns, transfers, and conveys all such results and proceeds, and all rights of every kind or nature, whether now known or hereafter devised in, and to such results and proceeds to CAM. Therefore, plaintiff cannot allege ownership or right to possession of the property at the time of conversion. Well, their contracts, they just cover every base.
Well,
So it's
see
like when we sign
here,
those non-disclosures,
yeah.
that's what.
Well, yeah, but the thing with this last paragraph you just read, now they're admitting that they used his work,
Mm-hmm.
but they're saying, well, yeah, we used it, but you turned it over and you knew under this contract that we own it, so
Yeah.
therefore we owe you nothing. And I don't know that I necessarily agree with that.
Well,
Anyway.
It's interesting that they use the word agreement to get to say it's okay for us to use it, but they're binding him to the contract for money, right? Now, I don't know if agreement and contract are the same because I haven't read the contract yet. Have I?
I don't know if there is a contract.
Well, there is, but it was
they're
that
saying
second.
it's attached.
That was that exhibit 2 that we got after the original reading. We didn't have exhibit 2, but then we got it, and that is.
And I don't think I've seen that.
Yeah, I don't think I have either.
Yeah, it.
So they're binding him. They're saying the contract supersedes the agreement, but yet they're going back to the agreement to get away with swindling him out of his work property through Schuler. Am I right? Do you see that?
It sounded like to me. But...
Yeah. And so what you got is a bunch of sleazy ass lawyers trying to out sleazy one another. And this is interesting. Just because it's just displaying the sleaziness, sliminess, just how this,
I think
I'm going to hold you to the contract and not and not listen to anything we said in the agreement, but I'm going to use the agreement for me.
I'll take this down, but this is it right here. This is the redacted one that was signed.
Okay, this is an agreement. This is not a contract. But then it later said that, what was it that superseded this?
Yes. So we're looking for 2 documents, one on the 18th and one on the 2nd, right? January 18th and February 2nd. Does that sound right?
This is it right here. This is the February 2nd agreement, which Kratz considers their contract.
So does Transition. They're calling the February 2nd signed document the contract.
Yes.
They're saying that there was a different one. I think that's the handwritten one, right? Or not, I might be flashing back to something else. So the one January 18th is an agreement. And then there's one on February 2nd, which is the actual contract. So they're binding Kratz to the February 2nd document. And they're binding. And now we got to see if the Brenda Schuler thing or whatever it is, they were like, we got to see what's written and what. That's interesting. I'm just curious. Why is it a contract on the 2nd and an agreement on the 18th?
Well, because they were still bartering. They were still, I guess they had already been talking, and then Kratz, I think, started formalizing things in the 18th, letter of understanding, and that letter of understanding then got turned into this agreement, which is the contract.
And I wonder what the key differences are besides the little bit of money. I know there's some
Well,
money
yeah.
amount changes.
There were a couple of changes that got brought up in this that were, as you can see, marked.
Mm-hmm.
And then it goes on and on and on.
What they
some
say,
more.
paragraph 9. Count down 9 paragraphs and let's see what it says.
This is, Kratz signed it with 2 of 13 amendments.
Okay.
Paragraph 9, I don't know where the hell that's at. It's way up here.
Yeah.
7, 8, 9. There's 9 right
Right.
there. The right to copyright. The right to copyright any such television programs, motion pictures, other properties, sound recordings, musical compositions, and all other copyrightable works based on or derived from the property, and to secure copyright and trademark protection to all works based on or derived from the property. This gets pretty lawyerly, if I can use that word. It's pretty thick when we read it.
Yeah, there's another number 9, Jack. This is a subsection of some number.
Okay. Maybe
There's
that
a
one
9 right there.
Ownership.
Ownership.
Yeah,
We
this
ain't
one's
got to
pretty
read
long.
all that. Yeah, that's a whole lot. But
I
I bet
think
you that's,
okay.
they're saying that they own the Brendan Dassey, Stephen Avery stuff because of that.
Broadcast from
paragraph.
basement speaker to the bedroom.
If you see right here, Kratz hereby waives all rights of Droit Morel, or moral rights of authors and any similar rights. It gets real thick in there, man. I'm telling you, they covered every nuance. So anyway, let's get back to it.
I just find that interesting. I'm
Very.
curious to see if they're pulling from the 18th or not. I think is what has struck my curiosity.
Well, I mean they talk about it, but in reality, Exhibit 2 is the contract. That's really where they have to really work from. And I want to say one more thing before Susan continues. Again, I'm surprised that Kratz didn't name Brenda Schuler in this lawsuit. I'm surprised. Not shocked, but I'm surprised because he goes after her pretty hard in his original complaint. Anyway.
She probably doesn't have anything he wants.
Well, maybe, but an opportunity to.
What does he want? He wants money.
He wants money.
That's right. And Brenda Schuler isn't rolling in it the way that he believes Rick and them are.
Well, probably not, but that doesn't mean she's not wealthy to some degree and he could get his hands on it. I'm just saying, I'm not saying that's what he's after from her. I'm just saying because of the way that the complaint was written.
Yeah.
Anyway.
Oh, I agree. But it's curious. This whole thing is curious. It's I don't want it dismissed because the more they stay in court, the more documents we get and the more get them on the record making statements about this case.
Well, and other documentation could float up from the sub-basement like it did in Colburn's case.
Yep.
We got a lot of material that we would have never got otherwise.
We got a lot of context about what kind of person these fine, upstanding, law-abiding officers and attorneys really are, right?
Mm-hmm.
So.
All right, Susan, you want to continue?
Christina, you want to read a little bit?
I can read some. Where are we at? Let's
Number
see.
4 on the screen.
Number 4.
Would you rather me send you the document?
You can send it to me. Yep, and I can read it off my phone while I'm on my laptop. Yes. You gonna send it to me in Discord?
I am.
Okay.
And
And StreamYard. I think
There you
it's
go.
right in here again. Oh, yep, got it. And we're on page 7.
Page 7 of the page 7 of the PDF. Start at number 4.
Okay, give me just a second. 8:31, that's now. And oh my gosh, it's 29 pages. What
Yeah,
could
like I
they
said, a
say?
lot of it's full that the index and all that. So it's not.
Okay.
There's
Oh,
probably
yeah,
like 20
let's
pages.
see.
Hey, excuse me 1 second. I'm going to dip out, but I will be back in just a few minutes.
Okay.
It's gonna give me a second. I'm almost there. I am on page 7 now. So number 4.
Yep.
Plaintiff's accounting claim must be dismissed. Under Ohio law, a demand for an accounting does not form the basis for a standalone action, but is instead a remedy. This is from do you want me to read the cited cases out?
That's entirely up to you. I'm not going to, if you want to,
I'll just
you can
read the
you can read
names.
you don't have to
Okay.
read the actual citation.
All right. Mark Termini Associates versus Clutch Sports Group, LLC. Moore Family Trust versus Jeffers. Mateo versus FOIA. An accounting, like a constructive trust, is an equitable remedy, not a cause of action, and the claim for an accounting remedy is properly dismissed under Ohio RCP. Here, plaintiff's complaint raises a standalone claim for accounting. Ohio does not recognize a standalone claim for accounting. Therefore, the court must dismiss plaintiff's claim for accounting for failure to state a claim upon which relief may be granted. B. Ohio's statutes of limitations prohibit plaintiff's claim. Plaintiff's claims for conversion, fraud, and civil conspiracy should be dismissed because they are barred, that's funny, by the applicable statutes of limitations. New England Healthcare IMPS Pension Fraud versus Ernst & Young, LLP. A motion to dismiss on statute of limitation grounds should be granted when the statement of the claim affirmatively shows that the plaintiff can prove no set of facts that would entitle him to relief. Pursuant to the Erie Doctrine, state statutes of limitations must be applied by federal courts sitting in diversity. Smith v. JJB Hillard, W.L. Lyons, LLC. Quotation omitted. 1. Plaintiff's conversion claim is time barred under Ohio law. Under Ohio law, a claim for conversion has a 4-year statute of limitation. Ohio Rev Code State Statute 2305.09b. A cause of action for conversion accrues either when the plaintiff discovered or in the exercise of reasonable diligence should have discovered the conversion. Carlin versus Carfangia, number 2000-T-0081, I'm done. Here, the alleged conversion occurred in or around December of 2018. Complaint, paragraph 56. Plaintiff became aware of the alleged conversion no later than January 29, 2020. Id at paragraph 57. Plaintiff sent demand letter regarding alleged conversion of the intellectual property. Each of the years alleged in the complaint fall outside the 4-year statute of limitations and are time barred. Therefore, the court should dismiss plaintiff's conversion claim. 2. Plaintiff's fraud claim is time barred under Ohio law. Under Ohio law, a fraud claim has a 4-year statute of limitation. Ohio Revenue Code State Statute 2305.09c. For a cause of action for fraud, the statute of limitations begins to run when the plaintiff discovers or through the exercise of reasonable diligence should have discovered a plausible or a possible cause of action. LeBur versus Bishop, 2014, Ohio 236, paragraph 14. Here, plaintiff's fraud claim is barred by the statute of limitations. Each allegation related to the fraud claim occurred outside the 4-year window. See complaint, paragraph 4. Plaintiff realized the full breadth and scope of this conspiracy in late 2019. Id at paragraph 62A, alleged fraudulent misrepresentation made January 7th, 2018. Id at paragraph 62B. Plaintiff acknowledging that no later than February 6, 2020, he had discovered the alleged fraud. Id at paragraph 62C. Plaintiff acknowledging that no later than January 2019, he uncovered alleged fraud regarding Ms. Schuler's role in the project. Indeed, plaintiff acknowledges that he was aware of the alleged fraud going back over 7 years. Therefore, the court should dismiss plaintiff's fraud claim. 3. Plaintiff's civil conspiracy claim is time barred under Ohio law. Similarly, plaintiff's claim for civil conspiracy must be dismissed because it is outside the applicable statute of limitations. Under Ohio law, the applicable statute of limitations for filing a civil conspiracy is the relevant limitation statute for the underlying cause of action. Davis v. Clark County Board of Commissioners, 2013, Ohio 2758. Here, plaintiff's civil conspiracy claim is based on his fraud claim. See complaint, paragraph 3. This civil conspiracy was accomplished when the defendants fraudulently induced plaintiff to sign agreements in which plaintiff was promised monies which defendants, upon information and belief, never intended on actually paying plaintiff, and in fact, to date, have not paid to plaintiff. Id at paragraph 66, alleged civil conspiracy, based on the refusal of each of the defendants to communicate with plaintiff as to project updates and other project status requests. As demonstrated above, the underlying fraud claim is barred by the statute of limitations. Accordingly, the civil conspiracy claim is likewise time barred. C. This court lacks personal jurisdiction over Hale and the Daily Wire. The court should dismiss plaintiff's complaint against Hale and the Daily Wire for lack of personal jurisdiction pursuant to Fed R Civ P 12B2 to establish personal jurisdiction over Hale and the Daily Wire, non-citizens of Ohio. Plaintiff must show, 1, that Ohio's long-arm statute, Ohio Ref Code, State Statute 2307.382, confers jurisdiction, and 2, that granting jurisdiction comports with due process. Calfalone Court v. Rowlett, a court must dismiss an action against non-Ohio residents who lack the minimum contacts with Ohio necessary to satisfy the due process analysis, even if a defendant's contact with the state of Ohio satisfies Ohio's long-arm statute. Personal jurisdiction fails unless exercising jurisdiction over the defendant comports with traditional notions of fair play and substantial justice. That's from Taubman v. Ladd RX Corps. Due process requires the defendant to possess certain minimum contacts with the forum state such that the maintenance of the suit does not offend traditional notions of fair play and substantial justice. Johnson v. Griffin, quoting International Shoe Co. v. Washington. Contacts with a forum state may generate 2 potential types of personal jurisdiction over an out-of-state defendant. Specific jurisdiction arising from the defendant's case-related contacts and general jurisdiction arising from the defendant's generic connections to the state. Id, quoting Power Invens LLC. To possess specific jurisdiction over an out-of-state defendant, the defendant's suit-related conduct must show a substantial connection with the forum state. An individual is subject to general jurisdiction in his place of domicile. And that's from Ford Motor Co. versus Mont 8th Judicial District Court. Citation omitted. All purpose forms for general jurisdiction are a corporation's place of incorporation and principal place of business. That's from Snabel v. Great States Court, quoting Daimler AG v. Ballman. A corporation with operations in every state is ordinarily subject to general jurisdiction in only 2: its place of incorporation and its principal place of business. For a court to find general jurisdiction in a forum other than a corporate defendant's place of incorporation or principal place of business is the exceptional case. That's quoting Snabel at star 7, quoting BNSF Ryko v. Tyrell. Continuous and systematic contacts are not sufficient unless they render a corporation essentially at home in Ohio. Here, plaintiff's complaint fails to establish either specific or general jurisdiction against Hale and the Daily Wire. First, the allegations in the complaint do not allege that Hale or the Daily Wire's purported conduct has a connection with Ohio, let alone a substantial one. Second, neither Hale nor the Daily Wire have general jurisdiction in Ohio. Hale is an Illinois resident and is not domiciled in Ohio. See complaint paragraph 10. Therefore, the court does not have general jurisdiction over Hale. see Ford Motor Co. at 358-359. Likewise, the court lacks general jurisdiction over the Daily Wire, as it is a Texas limited liability company with its principal place of business in Tennessee.
I didn't know that.
Yeah, I didn't either. That's interesting. Notwithstanding, there are no allegations that this case meets any of the 9 circumstances set forth by Ohio's long-arm statute, Ohio Rev Code Substatute 2307, a Kotak v. Gossinger City Toyota, dismissing claims against defendant for lack of personal jurisdiction, where the court determined that plaintiff's allegations, construing them in his favor, failed to reach defendant under Ohio's long-arm statute. That's wow. Therefore, plaintiff's complaint against Hale and the Daily Wire should be dismissed for lack of personal jurisdiction. D, the complaint fails to adequately allege diversity jurisdiction. Federal courts have subject matter jurisdiction in certain cases where there is complete diversity of citizenship. ACNO 1010 Market Street, St. Louis, Missouri, LLC versus V. Nahid Portagi. 28 USC substatute 1332 provides for federal subject matter jurisdiction in all civil actions where the parties are diverse and the amount in controversy exceeds 75,000. Parties are considered diverse when the lawsuit is between citizens of different states, citizens of a state, and citizens or subjects of a foreign state, citizens of different states, and citizens or subjects of a foreign state are additional parties, and a foreign state as plaintiff, and citizens of a state or different states as defendants. The Brown v. Lust 487F supplemental, and it goes on. In a diversity action, the party asserting diversity jurisdiction bears the burden of establishing the party's citizenships. This means that a plaintiff, this means that a plaintiff must fully allege the citizenship of each party. Alleging that an LLC is organized under the laws of a certain state does nothing to establish its citizenship. Rather, LLCs have the citizenships of their members and submembers. Thus, when an LLC is a party in a diversity action, the court must know the citizenship of each member and submember. ACNO at 627. Failure adequately to allege the basis for diversity jurisdiction mandates dismissal. That's quoting Cotton v. Burrell. Plaintiff has failed to establish that this court has diversity jurisdiction to hear this case. While plaintiff alleges diversity of citizenship between the parties, complaint paragraph 15, he fails to fully allege the citizenship of the Daily Wire. Plaintiff alleges only that the Daily Wire is a limited liability company, duly organized and registered under the laws of the state of Texas, with an address of 1831 12th Avenue South, Suite 460, Nashville, Tennessee. I don't even want to know. Plaintiff fails to identify and allege each member of the Daily Wire or each member's citizenship. This is fatal to diversity jurisdiction. Cotton at 4. Therefore, the court must dismiss the complaint for lack of subject matter jurisdiction. 2. In the alternative, this court should compel arbitration and stay proceedings. A. Ohio law and the Federal Arbitration Act favor enforcement of agreements to arbitrate. Under Ohio law, arbitration is favored as a matter of public policy, and any doubts relating to arbitrability should be resolved in favor of arbitration. You can't make it up. L&M Hospitality LLC, or L&M Hosp, because I don't know what it stands for, LLC v. Lavani. An agreement to arbitrate must be enforced unless it may be said with positive assurance that the arbitration clause is not susceptible of an interpretation that covers the asserted dispute. Doubts should be resolved in favor of coverage. Short v. Resource Title Agency, Inc. Quoting Academy of Medicine of Cincinnati v. Aetna Health, Inc. Ohio and federal courts encourage arbitration to settle disputes. ABM Farms, Inc. v. Woods. Citations omitted. Our General Assembly also favors arbitration. Ohio Rev Code Substatute 2711.02 requires a court to stay in action if the issue involved falls under an arbitration agreement, and under Ohio Rev Code 27 Substatute 2711.03, a party to an arbitration agreement may seek an order directing the other party to proceed to arbitration. Ohio case law strongly supports the arbitration of disputes. Short at paragraph 8, citation omitted. The Federal Arbitration Act, FAA, provides that arbitration agreements shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. 9 U.S.C.
Statute 2.
Yeah, substatute 2. I do not want to, for some reason, my brain does not want to remember what that stands for. The plain language of the FAA requires courts to rigorously enforce agreements to arbitrate. And that's quoting Dean Winter Reynolds, Inc. v. Byrd. By its terms, the Act leaves no place for the exercise of discretion by a district court, but instead mandates that district courts shall direct the parties to proceed to arbitration on issues as to which an arbitration agreement has been signed. At 218, emphasis in original and citation omitted. Because Congress enacted the FAA to reverse centuries of judicial hostility to arbitration agreements and place them upon the same footing as other contracts, the FAA not only permits private parties to agree to arbitrate their disputes, but also requires a reviewing court to place such agreements on equal footing with other contracts by compelling arbitration whenever there exists a valid agreement to arbitrate the dispute at hand. Why am I getting a feeling they're willing to pay him to go away?
Well,
Sure.
they keep pounding on this. Let's go arbitrate and talk about it. So I don't know. We'll see.
That's what it
That's
sounds
kinda-
like to me.
Yeah, that's kind of interesting, isn't it?
Yeah.
Yeah. That's kind of interesting. The FAA not only permits private parties to agree to arbitrate their disputes, but also requires a reviewing court to place such agreements on an equal footing with other contracts by compelling arbitration whenever there exists a valid agreement to arbitrate the dispute at hand. And that's quoting Shirk v. Alberto Culver Co. Internal quotation marks and citation omitted. Dean Witter Reynolds at 21920. Indeed, the FAA compels such a strong presumption of arbitrability that any doubts concerning the scope of arbitrable issues should be resolved in favor of, let's find another way to say arbitration. Moses H. Cohn Memorial Hospital v. Mercury Construction, superseded on other grounds by 9 U.S.C. The mandatory provisions of the FAA do not permit parties to an arbitration agreement to ignore the contract and resort to the courts. Such a course could lead to prolonged litigation, one of the very risks the parties, by contracting for arbitration, sought to eliminate. Southland Court v. Keating, enforcing agreement to arbitrate in franchise agreement. All right. And who's next?
Jay, you want to read?
Okay, I'll continue. The FAA embodies a liberal federal policy favoring arbitration and reflects the overarching principle that arbitration is a matter of contract. Discovery, I don't know what that, Ress Inc. and Ernest Young. When deciding whether the parties that agree to arbitrate the issue of arbitrability, courts generally should apply ordinary state law principles that govern formation of contracts. First options of Chicago Inc. and K-Plan. Here the agreement provides any claim, controversy, or dispute arising under the agreement shall be governed by the substantive law of Ohio. Agreement subsection 18. Accordingly, Ohio's contract law applies when reviewing the agreement's arbitration provisions. See Discovery Res Inc. Given the choice of law provision contained in the service agreement, we apply New York contract law principles to the issue of arbitrability. Here the agreement dictates that the plaintiff claims against CAM must be adjudicated in arbitration held in Cleveland, Ohio. See agreement subsection 18. Any such claim shall be submitted to arbitration before a single arbiter in accordance with the rules of America Arbitration Association held in Cleveland, Ohio. Plaintiff cannot properly seek relief in this court, but must pursue relief via arbitration. Accordingly, the complainant shall be stayed pending arbitration on the basis alone. B. All claims against all defendants are subject to arbitration. The Federal Arbitration Act permits a non-signatory to rely on state law, equitable estoppel doctrines of enforcement and arbitration agreement. GE Energy Power Conversions, FRSAS Corp. and Outokumpu, Stainless Steel USA, LLC. Ohio courts have recognized two circumstances in which non-signatories to an arbitration agreement can invoke equitable estoppel to compel arbitration against a signatory.
You don't have to read all
It's
those
a load of
citations there.
all things, so I just
Yeah.
missed that. The quotation and citations omitted. When a willing non-signatory seeks to compel arbitration with a signatory who is unwilling to arbitrate, Ohio courts perform an alternative estoppel analysis. The first circumstance is where a signatory relies on the terms of the written agreement in asserting claims against a non-signatory. The second circumstance is where the signatory alleges substantial independent and concerted misconduct by both the non-signatory and one or more signatories to the contract. Courts have acknowledged that it is the best interest of judicial economy to have all claims arbitrated together. Here, plaintiff asserts a breach of contract claim. See complaint 25 to 44 paragraphs. Plaintiff cannot seek to enforce the agreement against the defendants while seeking to avoid the arbitration clause contained in the same agreement. Further, each claim and each defendant are substantially interdependent with the alleged misconduct under the agreement. All claims and all defendants are significantly intertwined. Therefore, the court should compel arbitration for all claims. 3. Conclusion. For the foregoing reasons, the court should dismiss plaintiff's complaint in its entirety, or, in the alternative, compel arbitration and stay proceedings. Respectfully, Griffin R. Rayals. And then it lists a lot of detail
go.
from.
I told you it wasn't.
solicitor's address.
There's, you got the certificate, and the certificate of service, yada yada yada. So I knew there was roughly 20 pages of actual reading, but it gets pretty thick, and clearly they're wanting to arbitrate because they really went deep into that. Well, you should throw it out, but if you're not going to throw it out, let's arbitrate. You should force them to arbitrate. And they said this over and over, at least, 40, 50 times in there, that word arbitrate was there.
Yeah.
So,
At least.
I'm not, I'm not a lawyer. I don't think we have Travis in the audience tonight, but I'm sure at some point when he gets time, he'll probably take a look at this and give his opinion. Don't know this lawyer. He's clearly got a partner there. Certainly don't, I don't even pretend to know civil law, just what we picked up mainly from the Coburn v. Netflix lawsuit, which was, I learned a lot in that. I learned you don't mess with Leah Walker from Netflix, right? Or that they hired. That woman is, oh my God, mind like a steel trap. Anyway, I want to welcome Colette. I see she's joined. I've tried to kind of keep up on the side, but I really couldn't. See behind the magic. I don't know if she was here earlier or not. Kansas Boxley. Andy. Is this document designed to blind with science? Oh, Lord have mercy. Dr. Soapman. In short, Mr. Kratz, you were procedurally barred. Go home. Well, I had brought this up before about the statute of limitations. The only thing that I could possibly say that might tell the court, hey, look, he was trying to get information and basically he was stonewalled, couldn't get really much of anything, but he was trying. So that might compel the court to say, well, okay, we're going to allow it because he couldn't get any answers from, anyone at transition or anyone else, but he did try. So under those grounds, I think a judge might say they're going to let that go. I don't know that. I don't. So anyway, this is the next one. It's far shorter. It's only 8 pages. Probably, I don't know. I don't know if it's 8 full pages of reading or maybe 6 or 7, but we'll see. Because there's generally a thing of service at the end and so forth. It's on a separate page. This is document 16. It's filed on May 2nd. And I will say that they did, for those that don't know, they did file a letter to extend to get a little more time before their actual reply was due. So I guess I'm sure that was granted because it wasn't thrown out. So they probably got a little extension to get everything going. So anyway, this is a memorandum of defendants in opposition to the plaintiff's motion for preliminary injunctions. Since you didn't read very much, Jay, you want to read a little bit of this? You read whatever you want. You read a little bit of that, or whatever you want to read. It doesn't matter to any of us. Read as much as you want.
Right. Plaintiff Kenneth R. Kratz. Plaintiff March 20, 2025. Motion for a preliminary injunction. Motion is vague on what injunction he is actually seeking, and even more vague on the rationale in which to why the court should grant an extraordinary measure. On one hand, plaintiff asks this court to enjoin defendants Transition Studios, LLC, Christopher Reck, Ralph McCready, John Frack, Andrew M. Hale, Convicting a Murderer, docuseries LLC, and the Daily Wire, collectively defendants, from releasing or caused to be released financial royalties which the plaintiff is owed. Motion paragraph 3 or page 3. While on the other hand, requesting that the court enjoin defendants from releasing any additional project monies to third parties. March 20, 2025, affidavit of Kenneth R. Kratz. Presumably, plaintiff is asking this court to freeze the assets of CAM to maximize plaintiff's payout. Notwithstanding the ambiguity in his request, plaintiff fails to meet the burden in demonstrating a preliminary injunction is warranted, especially because the only harm identified is a monetary one. 1. Law analysis.
There's a footnote there.
Oh, is there?
On the
There
bottom.
is. There it is. There at the bottom.
Yeah.
Contemporaneous. Contemporaneous.
With the memorandum in opposition, defendants file the motion of defendant to dismiss complaint or an alternative motion to compel arbitration. Motion to dismiss, which is incorporated by reference here. There you go. Law and analysis. Faced with a motion for the preliminary injunction, a court must consider 1. Whether their motivant has shown a strong likelihood of success on the merits. 2. Whether the movement will suffer irreparable harm if the injunction is not issued. 3. Whether the issuance of the injunction would cause substantial harm to others. And 4. Whether the public interest would be served by issuing the injunctions. Farnsworth versus Nation Star Mortgages Limited Liability. Because of preliminary injunction, it is extraordinary, equitable, remedy that is never awarded was right, the plaintiff must make clear showings of these factors favour him. Lists a lot of quotations. A. Plaintiff will not suffer irreparable harm. It is well established that preliminary injunctive relief is unavailable absent a showing of
Irreparable.
irreparable injury, a requirement that cannot be met where there is no showings of any real or immediate threat to the plaintiff will be wronged. Where injuries have been an adequate remedy at law, such a sufficient monetary relief, they are not irreparable. Quoting Lyons at 111. Here plaintiff only claimed harm is monetary. See motion PP 2-3, emphasis added. Plaintiff is seeking a preliminary injunction to prevent injury, loss and damage by upon information and belief, reducing and possibly eliminating the monies from which the plaintiff can recover damages. Kratz's affidavit, paragraph 2. I am seeking an order from this court enjoining the defendants during the pendency of this action from releasing or causing to be released financial royalties which I am owed pursuant to the express terms of the February 2nd, 2018 Development and Rights Acquisition Agreement. Because plaintiff only claimed damages are monetary, there is no irreparable harm. See Kratz at TED. Therefore, the court should deny the motion on this basis alone. B. The plaintiff cannot show a strong likelihood of success. Although no one factor is controlling, a finding that there is simply no likelihood of success on the merits is usually fatal. Under Ohio law, to establish breach of contract, a plaintiff must allege the existence of a contract, performance by the plaintiff, breach by the defendant, and damages. Here, plaintiff is not likely to succeed in proving his breach of contract claim for three separate and independent reasons. First, plaintiff alleges only that the agreement between plaintiff and CAM, see March 2025 complaint with the jury demand complaint in exclamation marks. The January 15, 2018 agreement was signed by REC on behalf of Transition Studios with the promise to the plaintiff to present a long-form contract with the same terms on February the 1st, 2018. A long-form development and rights acquisition agreement was in fact executed by parties on or about February the 2nd, 2018. The development and rights acquisition agreement, or the agreement, superseded the January 15, 2018 Letter of Understanding, MOU. See the attached agreement attached to the complaint as Exhibit 2, subsection 19. The agreement constitutes the entire agreement between the parties with respect to the subject matter within, and all shall supersede all previous understandings and agreements. MOU attached to the complaint as Exhibit 1. This letter of understanding ... precedes a long-form agreement to be signed February the 1st, 2018. The agreement was signed by the plaintiff and CAM. No other defendants or parties to the agreement. Therefore, plaintiff is not likely to succeed on his breach of contract claim against those defendants. Second, most of the purported breaches alleged by the plaintiff were not obligations set forth in the agreement. For example, plaintiff alleges defendants breached the agreement by failing to identify, if any, actual direct out-of-pocket costs and expenses have been incurred in the project. Complaint, paragraph 28, failing to provide plaintiffs an opportunity to review the finished product for errors and omissions. ID that paragraph 31, and delay the project. ID at paragraph 33 to 34. Plaintiff admits there was no completion date for the project set forth in the agreement. At paragraph 33, plaintiff admitting the agreement is silent as to the completion date. Further, defendants, especially CAM, are under no obligations to provide financial updates to the plaintiff upon his demand. Indeed, he is owed only a percentage of the net profit after expenses are calculated. At paragraph 27, the agreement, subsection 5bi. Finally, while the plaintiff was entitled to consult on the project, plaintiff had no approval rights whatsoever in connection with any scripts created or television programs, motion pictures, or other properties.
Let's pause right here just 1 second. They're admitting that he's only owed monies, blah blah, whatever it stated there.
Yeah.
That's it. To me, that was an admission. Right?
Yeah.
So that's interesting.
I also just had a thought.
Yeah.
Maybe they want this to go to arbitration so they don't have to divulge how much money they made.
Well, and there's another part they haven't talked about yet that I've seen, and that's the investors. They kind of he kind of hinted at it earlier when he's talking about this lavish lifestyle and blah blah blah. But Kratz specifically talked about who all invested in. He was trying to, as I recall, he was trying to find out how much had been invested in by who, et cetera, et cetera. That's not being talked about here at all.
Yeah.
They probably brushed over that.
What's that, Jay?
They probably brushed over it. It's like what it says. If it's not mentioned, it didn't happen.
Well, or they just don't want to address it at all. They just want to let it slide. I'm sure that there's people out there that invest in various, films and documentaries and et cetera, that are not necessarily a named person in the film or whatever the project may be, but they've invested, capital expecting a return plus, whatever, 5% or whatever their agreement is.
Contract is, yeah.
That's right. I'm sure, I don't know it, but I feel fairly confident saying that, Sean Rex project with convicting a murderer would be no different.
And they may tell him that there are no net profits after expenses.
Well, they very well may.
Can y'all hear me?
Yes.
Okay. So if you go on Transition Studios and you read, I mentioned this, I think, before. If you read like what they're about, they are about putting out media, which is what convicting is, right? That controls the story you want told to preserve your legacy. Now, who do we know connected to the case that brought all this about that has the ability to toss $1 million or $2, right, into a project to simply continue the narrative that Manitowoc and those connected to putting Stephen and Brendan in prison didn't do anything wrong. Nothing to see here. Move along. Shoo shoo.
I can think of a couple. One of them's Vogel.
Yeah.
They're
Yep.
guilty. Or the
Yep.
state.
He's his wife is their family is extremely wealthy, so I'm sure
Very wealthy. Go look
I'm
in
sure
your
I'm sure he has access, or I would think,
Mhm.
I'm sure that. And then there's, for this project, there's Andrew Hale, who's made a extremely good living as defending police officers in the Chicago area.
And Chicago and Manitowoc are awful close to one another. I've said it before.
Oh yeah. Oh, yeah.
And I cannot shake that you unravel this case and it unravels a whole lot of dirty deeds done dirt cheap, right?
Yeah.
As ACDC would say, not only in Wisconsin, but in Minnesota. And now that Andy Hill has come on the scene, it's making me think there's probably some garbage up in Illinois that probably, and plus I know Gregory Allen was there. He's got a ticket from there. He's got a felony court case from there that nobody can seem to find. And
why am I not surprised?
Yeah, me either, right? And he spent some time there. So it's just it's very, very, very curious, to say the least. And
well, I think Susan maybe hit on it. They don't, go to arbitration, so these outside names are, not put in the
settlement
public
is
record.
Undisclosed. Yeah.
Yeah.
Uh-huh.
And they sign an NDA. Here's some money. Go away. Everything's sealed, and you're done.
And then once again, I think about Zellner making that comment to the gentleman who a lot of people don't like in this case, the older guy who did the video, where
Richard Boyd.
No, not him. The gentleman that was also helping on the Ricky Hostetler case, who oddly enough had an appointment with Teresa a few weeks prior. The older guy.
The guy that was their investigator, the Avery's investigator?
Yes, him. So that the comment that he made was that when she comes to Manitowoc, not only is her driver armed, which is not unusual, but she has multiple bodyguards. She comes like a dignitary pulling up into a war zone. You don't do that unless you know you are playing with people who are A, powerful, B, above the law, and C, are not afraid to kill you if you're in their way. You just don't.
Wow.
You know what I mean? Because you don't become wealthy by wasting money. And it would be a waste of money to pay for that kind of protection in some podunk town, unless you know for a fact these dudes are nasty. Because she comes to it like she's going into a war zone.
Yeah, I don't blame her.
Well, I know, but that's just not what you see. You do not see that. Not in America. Not unless you're playing with folks who are dangerous and powerful.
Huh?
And you know they kill if you get in their way. And then that makes me think about Peterson going on Dr. Phil saying it would have been cheaper to kill him.
Easier.
And he was the sitting sheriff
Yeah.
who didn't think twice about speaking that on national TV in front of millions of people.
Yeah, it was crazy.
It is crazy. So why, and this is Kratz. Like, it's curious, man. It's curious. Moth to the flame, moth to the flame.
Yeah, Andy, he followed what I said on X when I said that Cam was a failure and a flop, and Sean Reck responded to me. He said, "I'd like to have more failures and flops like Cam." Okay, well,
Yeah.
okay.
Yeah.
What do you mean? Are you saying it wasn't a failure? It made money anyway. All right, Jay,
What it did was it did what he set out to do, which was it encouraged those who were once seeking the truth to then decide that Stephen and Brendan were guilty, right?
Well, it was a snub. It was a huge snub. Number one, it was a huge snub at MAM at its inception. That's exactly what it was.
Mhm.
But hypocritically, they used the same format as MAM used, including
Yeah.
the danger music,
Yeah.
scary music. So it's just, I shake my head and I'm like, dude.
What it did was it showed those who, I'm going to tell you what it did. Okay. Convicting a murderer gave them data that now allows them to market the counter documentary idea to those wanting to change the narrative.
That's right.
That presented the right way, we can persuade people who once believed one thing. With the power of film, we can convince them to ignore the truth and believe the narrative we present if we present it in
a certain context.
And yeah, we can still change the narrative in the face of the evidence proving that it's a wrongful conviction. Because at the end of the day, let's say Stephen Avery did all the slimy stuff that convicting a murderer portrayed he did, right? Which most of that is still just he said, she said. 95% of it, there's no criminal convictions for it. What we did was we used some influential presenters to sell that, right? Because he wasn't convicted of all the things that they said he did. Yet again. And we were able to take these people who making a murderer made them question our conviction back in 2007. And now they don't care if he rots in prison or his 15-year-old nephew because, and I quote, Brendan might have done some of it and Stephen Avery's a piece of shit, unquote. Mind you, we're not saying that Brendan and Stephen committed the crime for which the prosecution stated they did, but we just think they're pieces of shit, so who cares? And that's not justice. And that's not the truth. And that does not solve what the question of what truly happened to Teresa Halbach.
That's right.
But we were able to present a story onto the TV, and there are people who will buy the lie if it's told correctly. To Andy Hill, it was an investment into a revenue source defending his favorite people, corrupt cops, and the DAs who try the cases.
Yep. All right, Jay, you want to continue? You want to pass off?
Somebody else can read if they want to, if they just want to finish, but I don't mind doing the rest, but it's up to you.
Susan, you want to read a little bit more?
Go ahead, Jay.
Right, okay. Third, plaintiff cannot show a strong likelihood of proving damages caused by defendants' purported breaches of contract. The agreement contains a limitation of liability provision in which his sole remedy is monetary damages. See agreement subsection 13. Plaintiff acknowledges and agrees that his sole remedy for any breach or alleged breach of his agreement by CAM shall be an action at law to recover monetary damages. The only monetary damages plaintiff is entitled under the agreement is a proportion of the net profits, which cannot be determined until all expenses has been accounted, which they have not. Notwithstanding, plaintiff cannot show a likelihood of success on his other claims, as demonstrated in the motion to dismiss. Plaintiff will not likely succeed on the unjust enrichment claim, count 2, because plaintiff fails to allege that he is conferred to a benefit onto defendants. Motion to dismiss, PP 3.5. Further, the unjust enrichment claim is summed by the breach of contract claim at PP 5-6. Additionally, plaintiff claims for conversion, count 3, fraud, count 4, and civil conspiracy, count 5, will not succeed as they are time barred at PP 8-10. Lastly, plaintiff claims for accounting, count 6, will fail because Ohio does not recognize a standalone claim for accounting at PP 7.8. Therefore, plaintiff cannot demonstrate a strong likelihood of success of merits. C. An injunction would cause substantial harm to defendants' creditors. Here, there would be a risk substantial harm to others, namely the defendants' creditors to which certain defendants owe money connected to the project. Plaintiff is not entitled to a guaranteed payout. Rather, he is owed a percentage of the net profits after expenses are calculated. Complaints paragraph 27, the agreement, subsection 5bi. Should this court grant the preliminary injunction and prohibit defendants, namely CAM, from making payments on the loans taken out in relation to the project, plaintiff will also suffer any prohibition on payments now will necessarily increase the interest accrued on the loans, risk default and accelerated payment, and incur penalties related to delayed payments. These increased costs would eat into the amount to which the plaintiffs would be owed after a final tally of expenses.
That's hilarious.
It is.
It is really, because you would have thought that if they round it all down within about a year, because they normally do accounts over a yearly period, it'll tell you what the outcome would be, wouldn't it? D.
But he wants to freeze their money until this is settled, which means he'll make less because they'll incur these
Other charges.
other charges.
Yeah.
Yep.
Oh, geez.
D. Public interest in not served by issuing an injunction. Relatedly, it does not serve the public's interest to force a party to default on its financial obligations to its creditors or to potentially miss payroll for its employees. As demonstrated above, the only alleged harm to plaintiff's monetary should be ultimately prove his claim by a trial. There are adequate remedies at law. Number 2, the conclusion. For these reasons, defendants respectfully request that this court deny plaintiff's motion. Respectfully submitted, Griffiths Royals.
And that's it. So they made numerous claims that it should be dismissed, or they really suggest arbitration. Let's get in a room and yada, yada, yada. Certificate of service. Anyway, so that's it. That's where we're at.
Kratz is just impatient.
Well,
I don't know if it's impatience or if it's. I had a thought. This is kind of a thought experiment, kind of an out there thought. So the way the contract is worded, let's say if you got wind of a potential movement in the case that may benefit the other side, the criminal case, what do you think would happen to viewers of the viewing audience of Cam? Would it increase or decrease?
well, I think it would increase. I think both it would increase for Ma'am and Cam.
Okay. So Kratz's lawsuit would be foolish or wise if there was discussion of a potential change in the criminal case.
Well, I think it would benefit any, especially national publication. If this, let's just say that this lawsuit here, the judge allows the case to move forward to the next steps, and it, let's say potentially is going to go to trial. I think it would increase awareness. People are going to say, well, what's this Cam about? I haven't watched that. Where's that at? What's on the Daily Wire? They're going to go what? They're going to go pay to watch it.
And do y'all also find it interesting that their LLC is in Texas, but they're based out of Tennessee?
I did find that interesting.
Not really.
I thought I didn't know it.
And what is this Ohio thing? I find
because transition is in Ohio.
I know, but if I recall correctly, you know who else actually resides in Ohio? If I might be off, but O'Kelly, I think his original business, like his home base is Ohio. Now, does he have LLCs all over? Yes.
I was thinking he was from Texas, but I could be wrong too.
No, but he ripped people off in Texas for sure.
Yeah, pretty much anywhere he goes, it's trying to rip them off.
Yep. So I'm curious if there is. We need someone who knows civil law in multiple states to help us understand why these companies are established in one state but practicing out of another.
Well, they can. I mean,
Oh
some
no!
lawyers have their they've passed the bar in several states.
Yep.
So
No,
they can
I
expand their
completely
business.
understand that, but I feel like these LLCs being like choosing domicile in a state and an LLC in a state and operating in a state. Like, I feel like this is intentional to try and circumvent legal issues that could
I'm sure it
arise.
is. I'm sure
Probably has to do
it
with
is.
taxes or something.
Yeah. All right. Or taxes. That's another good reason to do it. So if you're trying to be slimy, right? So if and just operating with that mindset kind of speaks to your moral compass, right? Because if you're trying to outsmart from the onset, then you're not really conducting your affairs ethically. Does that make sense?
Well, they're just trying to protect themselves from a legal standpoint, and I get that.
But if you're not doing anything wrong, why would you be worried about protecting yourself?
Well, that's what I'm saying.
That's my point.
It's like saying, they spelled it out, about Andy Hale. He doesn't live in Ohio. He resides in Illinois. Yeah, so he's not really part of it, but he was part of it. So yeah, it's slimy. It's legal trickery. Yeah.
If there's one thing I know about Andy Hale, just interacting with people in this case for the last few years, Andy Hale is probably one of the smartest attorneys attached to the Stephen Avery, Teresa Halbach, Brendan Dassey realm. Even though he has never
Debacle.
Yes, debacle. Andy Hale is smart. He's a very intelligent attorney.
Oh yeah.
And he has done. He's definitely well versed in the law, and
certainly from a civil side.
Yeah. Yep. Like if you put Andy Hale, Griesbach, and that other dude that was on Andy Colburn's case, who was also part of his Surik's team for a brief minute from Manitowoc, Andy Hale is like, I don't know, 35,000 feet above them in legal ability.
Yeah.
And that he's even attached to this says a lot. So he's been attached to Andy Colburn's case circumspectly, and now this case. And what was the other part?
I think that Kratz named these various people because I think he feels that they have a financial interest within transition, and again, not knowing for sure the list of investors and how much money, et cetera, was part of his original complaint. And I found that section there where this lawyer says that all the bills aren't paid yet. Well, why not?
That's what I was just wondering.
Yeah, why not?
Yeah, how long's it been? We're going on 3 years.
Because if Cam's been made and it's been through post-production and it's been shown on TV, that project's finished.
Yeah.
Well, it sounded like he's still paying back loans.
Yeah. This this was aired at the end of September 2023 through October, early November, I think.
Of 2023. So not
That's
quite
right.
2 years. So they probably pay out quarterly, I would think. So if it aired, 2023, they probably started cutting checks beginning of 24 on viewership. Because I'm sure you're not going to pay dividends like a weekend, right? You're going to, there's, how like you have your end of month and then you reconcile your accounts and you cut checks the 15th of the next month in most businesses, right? Is that how anyone else ever worked accounts payable, receivable?
Yeah, but for filmmaking, Jay
I don't
probably
have an idea.
A
Jay
lot of
probably
it's up front.
you're paid up front, you're done, right?
Yeah.
Well, I mean, but he was, correct?
Well, we don't know. We don't
The back end.
we don't know how much he actually got though. Kratz was a little vague about how much he actually got from transition in the beginning, and then certainly he complained that he didn't get. I think one was like a $25,000 payment, and I think another one was what was it, 40,000 or something by a certain date, or I
Could
think
have
it was.
something to do with his book rights, or
It did talk about using parts of his book, which they did, to frame
said they-
conviction.
but said they didn't.
Yeah, but
said
they really. Anyway, but then again, that contract said, once you pass it on to transition, CAM, whatever, it becomes their intellectual property, and they stated from here to hell and back every reason why it is. Dr. Sukma says, could Mr. Kratz force the producers of CAM to release a revised edition of CAM removing all references to Kratz? That's an interesting question, Doc. That would really alter quite a bit.
You guys really fucked my case. That's it.
That was a hell of a scene. Anyway, we've been rolling now for 2.5 hours, and before we get out of here, I did want to mention, for those, there are probably many that know, but this upcoming weekend is the Rally for Brendan, and Lisa Sikowski is going to be doing some live streaming. I'm not sure why Becca had to pull out, but she did. She's not going to be a part of it. I don't really know what's going on.
So she's not going to Manitowoc, huh?
Apparently not, and she's not streaming anything, so I'm not sure what's going on there. But I know that Lisa has been, trying to get as many people involved as she can. Myself and Duke are going to be doing a presentation after this rally. Now initially I haven't talked to Duke. I just talked to Lisa last night, but I suggested 7 p.m. Eastern time for our segment for the things that we're going to present in Brendan's case, and a lot of the
what
context
day
surrounding it.
Are you doing that on Saturday or?
Yeah, Saturday. Mm-hmm. Yeah, just this coming Saturday.
Are you wanting people to join and discuss? Or are you wanting people in the chat? Like, how can we support you?
Well,
Brendan,
if there's something you want to present specifically,
okay,
you're certainly welcome to join our segment. And I don't know how much time block she's got accrued for us. I'll talk to her and find out.
okay.
But this is we're part of the what's called the after party after the actual, I guess, public rally. They're going to be. I know she's trying. I know Dean and Jerry have committed to coming. Dean String and
Awesome.
Very cool.
She Kathleen Zellner said she might, if her schedule allows it. She's going to come. So I don't know who all else is coming. Lisa didn't tell me. I didn't ask her.
Are you talking about in person in Manitowoc?
Yeah.
Oh, cool.
Or at minimum being, part of a live stream.
Yeah, that'd be cool too.
Yeah, for sure. So let me make sure I got it right. So that is going to be on Saturday, May 17th.
Yep.
At 7 p.m.
Tentatively Yeah, tentatively 7 p.m. Now that could
Foul
alter a
play
little
is
bit.
going to be live streaming Eastern
Yes.
Standard Time around
Yes.
7 p.m.
Yes.
Okay. And we can join chat unless we get with you prior to, and we can present something if we choose to.
That's correct.
Okay. Gotcha.
I think Duke is going to talk about the burn pit, the bones. I'm going to talk about several issues surrounding Brendan, and it'll be what I present and my personal feelings, my personal opinion, I should say, not necessarily feelings, my opinion of what I see.
Which causes
And-
feelings.
Well, it's an event
Mm-hmm.
that begins and an event that ends, and what happened in between. So, anyway, it should be a really interesting thing.
Yeah.
In the world that we live in today, it's changed again. The paradigm shift of how things that we see reported in the media, and this kind of this area of
I don't know
wrongful
if
conviction.
Yeah, I don't know if anybody's following Charlie Kirk, if y'all listen to him, or he's kind of for the younger crowd. But what I find interesting, he goes to all these universities and then he encourages students to come up and talk to him and debate him because he's very vocal about his beliefs. And what I am learning from watching these videos, he's got an organization that's geared towards the younger, like the 20 somethings, right? The 18 to 30s. And what I am learning from watching these videos is how the internet gives out stats without context. Okay. And if you're not recognizing that you're getting a piece of information with nothing attached to it, you are quick to seize on it and make it conform to your worldview. So if you hate Jane Smith because she cut you off in traffic last week and you Google Jane Smith and it says that she once snatched her dog away from the curb just because, right? And then you start repeating that, you make it sound like she's cruel to dogs and she road rages. But then when you get further context and you find out that you ran a red light and almost, took her and her 3 children and dog out in the vehicle. And so she was a little upset by that. And 2, the dog tried to walk out when the pedestrian sign said clearly don't walk. And she snatched her dog back from getting hit by a car.
Perception. Context.
Yeah, exactly. So there, and that's kind of like what convicting a murderer is, right? It's taking pieces of a story.
Oh yeah, big time.
Pulling them out and then weaving them into the story that you want people to believe.
That's why we were never allowed to talk about the Halbach case in depth. They didn't want that.
And so, yeah. And so context is key. And it's also key to recognizing that there was a song years ago, I think Conway Twitty sang it, Rose-Colored Glasses. Do y'all remember that?
Oh, yeah.
We see the world through eyes that have been shaped,
Tinted.
yes, tinted to see it by what we think the world is. But our perception of the world doesn't make it what the world is. It's only what we want or think it is. The world is the world, not what we want the world to be. And so that's all of that. I'm just Stephen, this case has really been a key to unlocking how my version of the world is so skewed from the reality of the world.
Well, I
And-
think that on what you're saying there, I think that especially those of us that are a bit older, I know for myself personally, of what we were taught at school, even learned from outside sources, that it really, really opened millions of us eyes to the criminal justice system and how it really operates, and understanding that it's only as good as those that are in charge of it at any particular time.
That's for
the truth.
sure. That is for sure. I've always had the knowledge that cops aren't always good and district attorneys aren't always going to do the right thing, because I had experienced the opposite of what TV portrayed them to be from a very young age. So I knew that what we had, quote, been taught, unquote, wasn't necessarily the truth. I've always known that. But at the same time, I thought my ability to filter the truth from the lies was pretty daggum good. Okay. So I thought I had the right colored glasses on and I could see the forest through the trees. And I'm realizing that the changing of the lens comes in layers. The more that you accept that you don't know it all and you ain't got it all figured out, the better your vision becomes.
Absolutely.
The better your vision becomes into actually beginning to discern the truth through the lies. And so you always got to be willing to admit that, like, no matter what it is, you've always got to be accepting that you don't know it all and you can still learn. And so some people become hardened. Some people become jaded. Some people become, some of it's from bigotry, right? There ain't no woman going to tell me something I don't know. There ain't no woman from fill in this blank.
I think we become gravely disappointed too in the actions of people that are in authority and the way that they wield their power over a certain person, or in our situation, a couple of people. I look at the Karen Reed case and I see how this is just my opinion. I see how this judge acts towards the defense versus how she acts towards the prosecution. And it's night and day.
But you can put 100 people in a room, Jax, and 80 of them won't even notice it.
I notice it immediately. I think other people do too.
I know. So how do we, and Charlie Kirk, I think, whether you like him, don't like him, whether you agree with his political, religious, whatever, whatever views, whether you agree with how he in this moment sees the world, you have to have the ability to recognize that what he is saying is accurate, right? That we have allowed ourselves to be molded into individuals who, one, don't like to be told we're wrong, want to think that Google is right about everything, and that the cops always get it right. Just fill in the blank with whatever.
Right.
Okay. And if you approach any discussion thinking you know everything and you can't your mind can't be changed, then you're not going to allow yourself to learn more.
Well, you got to keep an open mind.
That's right. But saying you're going to keep an open mind and actually keeping an open mind are two different things, right? And that's where we as Westerners really need to recognize that we are locked. We have a tendency, I've got to learn how to speak in a way where ears hear this. We as Westerners have a tendency to think that we know it all. If we figure it out, then we figured it out, and all those things. What we've got to understand is that we can always have the ability to be wrong, and that's okay. And there are people who play on our ingrained belief that we know it all.
Well, it's
You know
emotional
what I
control.
mean?
It's that emotional control. I get it. I mean, I try my best to keep an open mind. I know, just reverting back to the Avery Desi cases, I know all the shitty stuff that he did. I don't think he.
So here's what
I
I'm
don't
going
know.
to say, because I know what you're going to say. I know all the shitty things that I've done, right?
Sure.
That doesn't make me a bad person. That doesn't make it okay for someone to convict me of a crime I didn't commit. It
That's
doesn't make it okay for people to continue to punish me, my children, my family, and others because they decided that I wasn't worth anything, and they decided that I didn't deserve, or I shouldn't have the ability to grow into a better person.
Right.
Because
Right.
we are all not who we were when we were younger. And
That's right.
so to write someone off, and I see this a lot, not just in the Stephen Avery case. I've known people who did drugs for years, and then they get sober, and then they forget about all the shitty stuff they did when they were active in their addiction, or
Right.
all the shitty stuff they did when they were in abusive relationships and they were the abuser or the abused one. And if you can't own your own shit and admit that, and then change, and admit that you used to do shitty things, but you're trying to be better and not bitter. If you choose to instead pretend none of that ever happened, it's easier for you to pretend someone else isn't redeemable.
Well, it becomes arrogance to me at that point if somebody's not willing to. I mean, I think as humans, we've all done things we're not proud of. Every one of us. There's not one person here or listening or that will listen that can claim perfection. There's just not. I've done some pretty crappy things in my life. I didn't really do anything illegal, but that doesn't mean that doesn't really touch on. That only touches on a small section of things that you can do that are, you shouldn't have done that. You're just stupid. You can blame it on lack of whatever, but in the end, you just got to accept it as who you are and accept people. I mean, short of somebody like Dahmer, you get into some really crazy. I watched a case the other night about where this woman was dating this younger kid, He was an adult, but he of age, but he was still quite a bit younger than her. And they got together and decided to do some meth or whatever and have sex. And somehow she got it in her mind it would be a good idea to stab him, cut him up, cut his head off. She chopped his leg off, took it with her, left his head in a bucket, and his family's upstairs asleep. And then she goes home and leaves this. She took his internal organs and
Is that your business?
I've seen that. That's an awful case.
oh my God.
Crazy.
Oh my
She's
God.
whack
So,
You know,
job.
and she wanted to act like it wasn't a big deal.
Of course not.
That's mentally ill. I mean, serious mental illness right there.
So I just thought about a case I wanted to ask you about. Have you ever heard about the 2 kids from British Columbia that disappeared?
You know,
Not offhand.
I think I did see a headline, but I didn't read the story.
JD, you may have.
No, I haven't.
No. It's
have
like
you-
a 4-year-old and a 6-year-old. They wandered off from home. And now the mom and stepdad have split up. I think BBC is covering it. I was just curious. If y'all haven't seen it, I can't figure out, or I can't ask if y'all what y'all's thoughts are. But they just scaled back the search for them. They've been missing for like 7 days now.
Oh no.
And your score says it was Nova Scotia.
Nova Scotia. I knew it was somewhere up in that area.
Yeah, that's East Coast. Huh.
Yep.
Yeah, I haven't seen anything. I've been so
Yeah.
focused on Karen Reed.
If
Yeah.
I had to, like, my gut, I'm going to put it out there. My gut is saying mom may know more than what she's saying. But she's doing her best to throw all the shade on the stepdad. Now, that's where my gut is. I'm just going to put it out there. Anyone else in the chat, what are your thoughts?
I'm wondering.
And
Probably.
your
I watched
scars agrees with you.
I watched this
1000%.
channel called. I watched this channel called YouTube channel called Crime A to Z,
Uh-huh.
and they will take a case, you know, and they're not all murder. There's various ones, but they will start at the beginning, even going back to when these people that are involved were born, and kind of take you through a little bit. These are generally 20 to 40-minute videos, but around 30 minutes typically. And they go through the process and they tell, and they do a really good job of hitting the really key facts. And then what happens after somebody is whatever convicted or, you know, whatever. They go through it really well, and they do it in a very concise way. I'm wondering if they'll probably cover that case.
It's going to be interesting because the mom, I mean, there's just something odd about, I'll tell you, and I am not in any way saying she did something to her children, but the feeling that I get is the same feeling I got when I watched, who is the woman who drove her children into the lake?
Susan Smith. I just watched it.
Yeah. Yep. That's what I'm getting, Susan Smith kind of vibes. And I pray that I'm wrong.
I just watched that on Crime. I just watched that. They did Crime A to Z did that one.
Yeah.
And, you know, I remember that, you know, because that was one of the first really huge media stories that covered something like this, and how pissed off people were when it finally came out that she had done that. I know people that they would have killed that woman. They would have killed her.
So
I'm not kidding. They were livid.
So my mom actually went to the lake where she drove her children in. back then because she was up in that area and
That was in Florida, wasn't it?
Georgia.
Oh, Georgia. Oh.
Yeah. And she was pretty close, and I had went on vacation like right after that by herself. And for whatever reason, she chose to go there. And I mean, I don't know like I don't know why. She never really explained, but she mentioned that she went there. And I'm wondering, because you always wonder, like, why would you do that, Mom? And I'm wondering if she didn't ever have a moment where, like, because when you're a parent, sometimes you have these fleeting thoughts, right? Like when shit's just overwhelming, and that's just brutal honesty. Okay, especially single parents. And I've never had thoughts about driving my kids in the lake. Maybe myself, but not my children. Let me be clear. But I can remember when my oldest got an ear infection and screamed for 2 days straight, that I was like literally to the point of either pulling my hair out, screaming at the top of my lungs, or running away. And I chose to take a stick and go beat a tree because you feel so helpless. And so
I know that feeling.
Yeah, right. So if you take people who are wired a little bit differently than that,
Yeah.
where beating a tree to let out your frustration doesn't work, then those people are going to have different thought paths. Think about the lady in Washington who listened to the Police song, Hungry Like a Wolf, and then tried to stage like somebody had pulled her. It was like the first a failed carjacking attempt. She shot her children and drove herself to the police station and said that a black man tried to carjack her. Yeah. So it's kind of that kind of thinking. I think that's how I equate it, like me beating the tree, Susan Smith. And what was that woman's name? She tried to get out of prison too. The DA actually adopted one of her children that survived, or both of them. Yeah.
My mom always threatened us kids when I was little that she was going to get on a bus and leave town if we didn't shape up.
Yeah.
My mom didn't. She had a leather strap, and my mom was pretty hard to get mad. She was a great woman. So if you met, as kids, me and my brother, she would say, get your ass outside. When I get my leather strap, go play. I'm clean. I'm doing whatever.
Yeah.
You kids need to go get outside. See you later. And she wasn't
There were
being mean.
6 of us.
Oh my God.
I can understand. Yeah.
If my mama had 6 of me, I'd probably, I don't even want to know. Because I was a lot. I was a lot.
All right. We're pushing 3 hours. I want to get us out of here because I know Susan's hungry. I'm definitely hungry.
I'm starving.
I'm starving too.
I got a big burrito waiting on me. So
I have a funny little quick Karen Reed story that happened to me today.
Good.
I want to hear.
I stopped at the neighborhood market on my way home from work, get some groceries. And I wore my free Karen Reed shirt today. I have a t-shirt. And I was shopping, and this guy comes up to me and he says, "Excuse me, my wife is so totally entrenched in that case." She follows every little bit of information that comes out. I said, "Well, yep, me too."
That's funny.
Awesome.
No, it's hilarious. In Joplin, Missouri. People are all over the place. Yeah. I mean, it's worldwide.
Well, I mean, I think
attention it's getting.
I think we all can relate to it in some way, right? You know?
Well, it could be any of us. It's like
Exa-
Stephen.
yeah.
You know, he was framed, she was framed. It's the same
Yeah.
story. Yeah.
It,
Well, we go back to actions and events. No tail light stuff appeared until Proctor got his hands on her car, and then all of a sudden, we got 50 freaking pieces of tail light.
Yeah.
One more thing in that case.
Over a 3-week period, mind you.
Yeah, and one more piece of evidence in that case. I swear I'm gonna get us out of here. Is that drinking glass that they found where John was, and they didn't go inside and say, "Hey, did this glass come from inside here?"
Yeah. Oh, they found the straw, the stir straw.
Oh, that was out in the road, wasn't it?
Yes.
Several days after the fact.
They immediately surmised that, you know, she hit him with the car.
Then how did that drinking glass survive and not be laying in the road?
You know, it didn't happen, Jack.
I know. It's just stupid.
It's very
oh my-
stupid. Wait, I mean, they've already changed their timeline from the last trial.
Oh yeah.
He was hit in the first trial at 12:45, and this
Yep.
trial it's 12:32.
Yep.
because they proved that Karen was already home at 12:45. They changed their timeline during the trial in trial 1 because it was proved that Karen was home she connected to Wi-Fi at 12:36. So
that's pretty scary, and I think Nanslov said it. It's somebody said it something about it being scary, the criminal justice system, and it is. Again, my perception is that the criminal justice system, wherever you live in this country or around the world, is only as good as those that are running it at the time. We see this time after time after time.
Of course.
It's crazy. Anyway, I want to thank everybody.
I want to add one thing, just one more thing. You know, it's interesting. We put term limits on presidents, right? They're only allowed to serve for 8 years.
2 terms, that's right.
Okay, so we have Kusurik, who was sheriff for how long?
30-something years.
20.
Yeah,
22,
for a hot
22 years. Yeah, 22 years, I think.
Yeah, so for many, many moons. Okay. And then you mentioned the DA or who that ran unopposed for how many years in this case?
This attorney, yeah.
Okay.
Morrissey.
All right. So shit rolls downhill. If you've got a guy or a girl in charge who is okay with bending the rules 2 years in, and then they're allowed to continue in that vein for another 12, 15, 20 years, they're going to get rid of anyone who doesn't align with their way of work, and they're going to make sure they staff it with those who are. And right, that's just common sense.
Of course. Yeah.
Yep.
And so if we don't want the same president for more than 8 years, why would we want anyone else in a position of authority as a government employee for that long?
Like judges, Supreme Court judges.
Yeah.
Lots of judges, but yeah.
Yeah.
Until they die or retire.
It's
insane.
You know, because we are all human. None of us are perfect. None of us are perfect. We are all human and we all have flaws. So I think that is something that needs to be
change.
And you know, power corrupts. Power corrupts some,
Oh, for
not
sure.
everybody, but there
sure.
are. It's a human nature that some people are corrupted by power.
Yep.
And
And if you're,
you've got to be able to have the ability to get them out.
and if you're a little
Whatever
corrupt,
position.
if you're a little corrupt when you take office, the longer you stay in, the more corrupt you're going to become. So,
All right.
Get us
Well
out,
said.
Jack.
yeah.
We're moving on. I want to thank all the live chatters. Really appreciate you staying tuned as we get more documentation. In this case, we'll see what the judge decides. I would imagine it won't take too long because there's not that much to really decide on. But it'll be what it'll be. So once we get more information, we'll certainly share it. And I want to thank certainly Susan and Christina and Jay for reading these documents. They're got lawyer stuff. I will be getting. I'll get these on Google Drive for sure, and then until Zoe can get them in the library, I'll put a link in the description for anyone that wants the documentation. It'll be there. So with that said, until next time, I'd really like to get on one night and just talk about the Karen Reed case. We'll have to pick a time for that. But remember, this coming weekend, Saturday, I'm saying right now, 7 Eastern, Foul Play will be live to discuss the aspects of Brendan's case for his rally day. With that said, I'm going to say this has been a Foul Play production.